Constitutions. My name is Geoffrey Sigalet. I'm a research fellow here at the Research Group for Constitutional Studies. And I'm really excited to introduce our panelists today. We have three really interesting scholars, all writing about different aspects of constitutionalism. And so I'll just introduce them in the order we're going to have them speak. First, we have Erin Crandall, who is Associate Professor at the Department of Politics at Acadia University. Professor Crandall, or Erin, earned her PhD here at McGill, so this is a bit of a homecoming for her. She worked with Professor Manfredi, who presented yesterday. Next, we have Professor Hoi Kong, or Hoi, and Hoi is the Right Honorable Beverly McLaughlin Professor in Constitutional Law at the University of British Columbia, and also a scholar at the Peter Wall Institute for Advanced Studies. He's also having something of a homecoming because he was previously a professor of law and a founding member, I was just told, of the Research Group for Constitutional Studies. So that's exciting. We have two alumni or alumnuses here. And third, we have Professor Roberto Gargarella. Is that right? I'm not like Victor, I don't speak Spanish, but that was my best try. And Roberto, if I may, is a professor of political philosophy and constitutional theory at the Universidad de Buenos Aires and the Universidad Torquato de Tella. Is that right? And forgive me if I butchered that. Professor Gargarella, or Roberto, is also, I think, right now a distinguished visiting professor of law at the University of Toronto, if I'm not mistaken.
Yes, I was teaching in January.
And he's internationally renowned for his theories of constitutional dialogue, which I read as a graduate student and really interested me in that topic and led me to write my dissertation on it partly. So with that introduction, let's get down to business. As I said, we'll move in the order of my intro and start with Erin and move to Hoi and then move to Roberto. So Erin, the floor is yours. After we're through all of our speakers, we'll have some time for discussion between our panelists, and then we'll open things up for everybody else.
Great. And so I'll just start by asking that perpetual question, can everybody hear me? We're great. Okay, we're good to go. Wonderful. So firstly, I'd like to thank all of the organizers for this opportunity to participate in the conference, of course. And I'm especially excited to be here today because, as Geoffrey mentioned, I completed my doctorate at McGill. And I was in the midst of writing my dissertation when RGCS was founded 10 years ago. So I was part of that first cohort of graduate students who benefited from the office space, the resources, the scholarly engagement, and faculty support that were made possible by the creation of the center. And when I look back at my time at McGill, which now, once you're done the PhD, you get to think about all the good things. This is certainly one of the highlights, and I'm really happy to be back, even if it's from my home in Wolfville, Nova Scotia, which is very much not Montreal. So this paper considers the constitutional status of Canadian cities. And it's a topic that I had the opportunity to consider as part of the Massey Cities Summit, which took place a few weeks ago. And I'm very happy to be able to revisit it today as part of this conference on constitutionalism in the Free Society. The question of the paper is, are Canadian cities entrenched in provincial constitutions? Which is admittedly a kind of a funny question. So why ask the question at all? So firstly, there appears to be increasing scholarly and political interest in entrenching some sort of constitutional status for cities. And this makes sense given the increasing urbanization that is happening globally. So it's not just something that Canada is thinking about, but it's a question that cuts across countries. In Canada, I think a lot of this interest was spurred by the interference of the government in Ontario in the 2018 Toronto municipal election, when it shrunk Toronto's city council's membership in half from 47 to 25 in the midst of the election campaign. So the City of Toronto challenged the province's action in court, and the case was most recently heard by the Supreme Court of Canada in March of this year. So it is still a constitutional issue yet to be resolved. For reformers seeking to constitutionally entrench the powers of Canadian cities, like some sort of city charter, the expectation would be that this type of unilateral action taken by the government of Ontario during the Toronto municipal election would not be possible. And so this prompts the important question of how such a constitutional reform might proceed under Canada's constitutional amendment formula, which is set out in Part 5 of the Constitution Act of 1982. So any discussion of constitutional amendment in Canada is largely greeted with trepidation, not amongst scholars of the Constitution, but amongst elected officials. And the country has, to put a positive spin on it, struggled with formal constitutional reform. However, Canada's amendment formula has multiple procedures of varying levels of difficulty. And the two that are most relevant for the discussion of cities are Section 45, which deals with amendments to provincial constitutions, and Section 43, which applies to amendments to the Constitution of Canada that affect one or more, but not all provinces. So these amendment procedures have comparatively easier thresholds of consent compared to the amendment procedures used in examples of major constitutional failure like Charlottetown and the Meech Lake Accords of the late 1980s, early 1990s. An amendment under Section 45 only requires the majority approval of the provincial legislature, while an amendment under Section 43 requires the approval of the House of Commons, Senate, and the Legislative Assembly of the affected province. So in both of these instances, the major hurdle would appear to be the willingness of the province to devolve powers to this city, not necessarily the threshold of consent that is required. So given this interest in giving cities constitutional status, this paper looks to answer a kind of odd question. Are cities already a part of provincial constitutions? And for people who are interested in giving cities greater power and autonomy, which was part of the focus of that cities summit, this question is admittedly not helpful at all because the status quo is already viewed as unacceptable. So I want to argue that this is a question worth posing because it requires us to consider the nature of provincial constitutions as political constitutions, and secondly, why their status is ambiguously and poorly understood in comparison to the Constitution of Canada. Regardless of whether the proposition that cities are already part of provincial constitutions is convincing, I think we need to grapple with the nature of provincial constitutions as political constitutions in order to understand their capacity and potential for repositioning cities within Canada's constitutional framework. It might also be helpful to understand the politics behind provinces' unwillingness to enact constitutional change for cities in the future. So for the remainder of my talk, I'd like to briefly discuss why the ambiguity of provincial constitutions allows me the space to propose this question in the first place, and how this might be consequential for thinking about constitutional reform for cities. So as you might expect, there is little that is singular about a provincial constitution. Provincial constitutions are found in multiple sources, including portions of the Constitution of Canada, ordinary provincial legislation, common law, and unwritten constitutional conventions that are typical of Westminster-style governing, like, for example, parliamentary sovereignty. Despite this ambiguity, there is some consensus that certain statutes are part of a province's constitution, including the rules of a province's electoral system, legislative processes, executive governance, judicial acts, and human rights codes. However, even this list can't be treated as exhaustive, and it's simply the case that we do not have a definitive list of what is contained in a provincial constitution. The ambiguity that surrounds provincial constitutions is facilitated by their amendment procedure under Section 45, which requires only statutory enactments by the provincial legislatures rather than parliamentary resolutions passed by provincial assemblies. So basically this means that amendments to a province's constitution proceed by way of ordinary provincial statute. As a consequence, there's no requirement that an amendment to a provincial constitution must contain a distinctive clue, or key rather, that can identify it as a constitutional amendment. So while there's nothing to stop a provincial assembly from identifying the use of Section 45 in a statute, and this has happened on at least 2 occasions since 1982, provinces aren't required to do so, which means that we do not have a record of amendments to provincial constitutions under Section 45. So those 2 things together mean that we can't be confident what is contained in a provincial constitution, and also how many amendments have been made to provincial constitutions since 1982. So the position I take in the paper is that given that we cannot identify all the components of provincial constitutions, and that amendment procedures under Section 45 only act to further obscure provincial constitutions, there is arguably uncertainty around the status of Canadian cities in provincial constitutions. And here I should stop and say that Canadian municipalities are not recognized by the federal and provincial governments as having constitutional status. And current jurisprudence affirms this view, recognizing municipalities as mere creatures of the province. So this proposition that Canadian cities may reside in provincial constitutions is by no means an easy argument to make. And I'm not sure that I necessarily think the answer is that they are. That said, there are factors supporting a view that the status of cities and municipalities are part of provincial constitutions. As a number of scholars have argued, municipalities and municipal systems are fundamentally constitutional in nature. As well, in a number of important rulings, the Supreme Court has outlined principles that underpin Canada's constitutional structure, including federalism, democracy, the protection of minorities, and constitutionalism and the rule of law. And it seems reasonable to understand the constitutional status of cities as supporting some, if not all, of these principles. Additionally, the Supreme Court in Ontario v. OPSEU, a case from 1987, sets out some guiding questions for identifying provincial constitutional laws, like does it bear on the operation of an organ of the government of the province? Does it regulate the interrelationship between 2 or more branches? Does it set out some principle of government? And I think a reasonable argument can be made that for cities, a number of these questions can be answered in the affirmative. But my larger point in asking the question, are Canadian cities already part of provincial constitutions, is not necessarily to convince you that they are, because that is a very kind of thin scaffolding that I have built for myself there, but rather to encourage us to think carefully about provincial constitutions as political constitutions, and what that might mean for future efforts to constitutionalize cities, or more generally entrench provincial constitutions. So the trajectory of Canadian constitutionalism over the past 4 decades, I think, has certainly been towards a legal constitutional framework, which has increasingly relied on judicial review to enforce constitutional supremacy. Whereas political constitutionalism, to present it simply, embraces parliamentary supremacy. By contrast to the Constitution of Canada, provincial constitutions, at least when we were talking about statutes where the constitutional amending procedure under Section 45 applies, still follow a political constitutional framework. And this matters, I think, for constitutional politics. There are clear political benefits for provincial governments of all political stripes to maintain this political constitutional framework, as it serves to entrench political power in the political executive. And just practically, it makes their job of governing easier. And perhaps a good, though admittedly loaded, question that drives home this point is, why has Quebec never entrenched its own provincial constitution? Or perhaps a more straightforward example, why hasn't Alberta? Certainly part of it is that it is to the advantage of those in power, and regardless of the political party that is in power in a province, it is to their advantage to operate on what can be understood as a largely political constitution. So when we are talking about entrenching a provincial constitution or entrenching cities into a provincial constitution, we are also talking about a transition from a political constitutional framework to a legal constitutional framework. And given that the constitutional amendment procedures required to constitutionally entrench Canadian cities are relatively straightforward in terms of the level of consent that is required, the real barriers to change are not institutional, but rather political. And in political, in the way that we're thinking about their constitutional structure. And I think that when we're discussing changes to provincial constitutions, it is helpful to consider them in these terms. So those are the opening remarks that I'd like to make.
Great. Well, hopefully we'll be able to talk a lot more about that. But first, we'll turn to Hoi and his paper. So the floor is yours, Hoi.
Thanks so much, and thanks so much to the organizers for the invitation. As Geoffrey said, I was a founding member of RGCS, and which means that I've been teaching constitutional law for at least 10 years now. And as I was thinking about this, about the title of my thesis, about this paper, I was kind of worried that it might come off as kind of like a sort of constitutional law midlife crisis. You know, what is the Canadian Constitution? Sort of like, what is it all about? And so I want to show you that this is not, this paper is not the result of a constitutional law professor midlife crisis, or it's not only the result of a constitutional law professor midlife crisis. I think the question raises really sort of deep questions of constitutional theory and really interesting questions of positive constitutional law. I'm also, one of the reasons I'm also posing it is because I'm writing a book that's sort of modeled on the very short introduction series that Oxford University Press does. And so this initial question, what is the Canadian Constitution, is sort of the question that's been, that I've been asked to answer. So I want to start by saying that there are a variety of ways in which you can answer this question. And I think there are a variety of ways you can answer this question of any constitution. And so one way of answering the question is to say, what are the criteria for inclusion? Yeah? What are the criteria for inclusion in the Canadian Constitution? Second way of answering the question is to say, well, what about this Canadian Constitution makes it a constitution? Or put otherwise, what kind of constitution is the Canadian Constitution? Now, Erin has very helpfully done some of the groundwork for me by sort of laying out the contrast between political and legal constitutions. And I'll return to that distinction when I go into the sort of main example that I'll use to animate today's discussion. But I want to start with these two sets of questions. What are the criteria for inclusion? What kind of constitution? And we'll see that these two questions are kind of interrelated. So as we heard yesterday, there is a broad distinction in the literature between ancient and modern constitutions. Yeah. So modern constitutions are understood to be the result of discrete acts of will, and they are typically entrenched in a written constitution. Ancient constitutions are understood to not have the form, not to have a written form, not to be the result of discrete acts of political will, right? But rather rest on accumulation of experience over time. So we have a distinction between ancient and modern constitutions. Let's turn now to the criteria for inclusion in the Canadian Constitution. So as Erin has sort of alluded to, the Canadian Constitution has a clause which sort of defines what are the contents of the Canadian Constitution under a supremacy clause. And so section 52 of the Constitution says the Constitution includes these things. The first thing to note is that it lists documents that are kind of uncontroversial part of the Constitution, right? So 1867, 1982 Constitution Acts. And for those of you who don't do constitutional law, broadly speaking, these are provisions that are typically used to resolve issues around federalism and rights claims. Yeah, entrenched constitutional rights claims. These are uncontroversially entrenched elements of the Canadian Constitution, and they meet the supremacy clause criteria set out by the Constitution itself. That's one set of criteria for what counts as the Canadian Constitution. But the express language of section 52 is that the listing only includes these documents. It's a non-exhaustive listing. Now that's important because the second part of the Canadian Constitution, second criteria for inclusion in the Canadian Constitution, is a kind of broad understanding that in the way, along the lines of that Erin just set out for us around provincial constitutions, constitutions are also about instruments that regulate fundamental organs of government. Yeah. And so now those regulations, those instruments that regulate the fundamental organs of government need not be entrenched. Yeah? They need not be entrenched and need not have supreme status as supreme law. The clearest example of this kind of instrument, constitutional instrument, which regulates organs of government, but is not entrenched within the supreme law of Canada, are constitutional conventions. And so these are just practices that have to meet a certain test, which need not detain us here, right? But they are practices. They have the hallmarks of an ancient constitution. Yeah? They're about the accumulation of experience over time. They are not the results of discrete acts of will. Now, in the Canadian Constitution, a good illustration of this is the office of the Prime Minister. The office of the Prime Minister is nowhere mentioned in the Entrenched Constitution. It's nowhere mentioned in any of the statutes, in any of the written instruments. It is the result, but it is clearly constitutional in the second sense. It bears on the organs, fundamental organs of government. Okay, so that's by way of scene setting. Yeah. So what kind of constitution is the Canadian Constitution? Well, things fall within the category of the Canadian Constitution if they satisfy these criteria for inclusion. What kind of entity is the Canadian Constitution? It is both an ancient and modern constitution. Okay, so now why might that have any different purchase on the ground? And so one way in which this is kind of the mixed character of the Canadian Constitution, one way to enter into this question is to think about the criteria for inclusion for supremacy, right? So as I said, the criteria for the provision that sets out the supremacy clause is a non-exhaustive list. You know? So one of the things that has been included in the list of the entrenched constitution is an unwritten constitutional convention, an unwritten constitutional rule, that is parliamentary privilege. And so in a case decided by the Supreme Court of Canada, it is found that the parliamentary privilege, that is the privilege of parliamentarians, the inherent privilege of parliamentarians to exclude people from the Legislative Assembly, right? That inherent privilege is entrenched. And so it is not even subject to review under other parts of the Constitution. Yeah? So in the particulars of the case, there is an attempt to challenge it under a provision of the entrenched Charter of Rights and Freedoms, right? And the court said, no, it is not subject to challenge on those grounds because it forms part of the supreme law of Canada. Now, what's interesting about this, to the extent that it's interesting at all? Well, it's interesting because it sort of scrambles the dichotomies that between ancient and modern constitutions. Yeah? So what we have is an unwritten constitutional rule, not enacted as a discrete act of political will, therefore bearing all of the characteristics of an ancient constitution, entrenched through an interpretation of an instrument of the modern constitution, of the written constitution. Yeah. And so that is by way of illustration. That is by way of illustration of the complexity of the question, what is the Canadian Constitution? And in the ways in which the answers are complex, precisely because Canada's constitution is a hybrid of modern and ancient constitutions. Now I'll turn now to the final portion of this presentation to talk about a kind of motivating example, which I think will illustrate fully this kind of the stakes, what's at stake in this understanding of the Canadian Constitution as a mixed constitution. And the example I have in mind is patriation. So for those of you who are not familiar with Canadian constitutional law, patriation was the constitutional event which allowed for the Canadian Constitution to be amended by domestic actors such that it did not require the assent of the Imperial Parliament, of the Parliament of the United Kingdom. Yeah, so it's a fundamental constitutional act. It is, I think, and so in addition to bringing that power of amendment into the Canadian polity, the act of patriation also I would argue, sort of revolutionized the Canadian Constitution. It inserted into the Canadian Constitution a Charter of Rights and Freedoms, an entrenched Charter of Rights and Freedoms. Yeah. Previously, the sort of primary elements, entrenched elements of the Constitution dealt with the division of powers, the federation. So I think within general constitutional theory, it's plausible to say that patriation was an exercise of the constituent power. Yeah. It's an exercise of fundamental constitution making. And now in constitutional theory, constituent power or political sovereignty is typically understood to be kind of unconstrained by legal norms, unconstrained by legal constitutional norms. And so in the remainder of the time that I have with you, I want to show you that patriation was constrained. This act of fundamental constituent power was constrained by legal constitutional norms. Yeah, but those constitutional norms had a kind of mixed quality, a quality of being both ancient and modern. So here's the story of patriation. The story of patriation is that after 5 decades of fruitless attempts of negotiations between the federal and provincial governments, and they attempt to bring back the Constitution of Canada, to patriate it, to bring the amending formula into the Canadian polity, this fundamental constitutional power, there was 5 decades of impasse. And at the end of this 5 decades of impasse, the Prime Minister of the time, Prime Minister Pierre Elliott Trudeau, decided that he would patriate the Constitution through a unilateral act of Parliament. Yeah? And so the Prime Minister said, look, this is a fundamental act of political reform. The only body that can speak on behalf of the entire Canadian polity is the Canadian Parliament. And so the question was posed, well, is this constitutional? Yeah? Is this kind of an act constitutional? Now, at one level, this seems to be sort of a puzzling question. If it is an act of constituent power, why should it be constrained by constitutional norms? Yeah? And if it is constrained, what kinds of constitutional norms should constrain it? So the question goes to the Supreme Court of Canada under a reference, an advisory opinion. And the Supreme Court of Canada comes back and they say, in order to amend the Constitution in areas that affect areas of provincial jurisdiction, as this kind of amendment manifestly did, yeah, you require the substantial consent of provinces. Now, what the court said was, this is a constitutional rule, but it is a constitutional rule that is conventional. It is not an entrenched constitutional rule. And so you have this strange situation of a constitutional court, as Erin just said, that under sort of what you might call a legal constitution or a modern constitution, right, has enforcement powers, judicial review, right? The ability to review whether government action is constitutional and to enforce its decisions. Yet here, we have a court opining on an artifact of the ancient constitution, the constitutional conventions. Yeah. Yet nonetheless, the government of Canada sort of accepted this ruling and then went into further negotiations. Now, the basis of the reform of substantial consent is a kind of respect for an underlying principle of Canadian federalism. One of the ones that Erin just mentioned, the principle of federalism. Yeah. So it makes a certain amount of sense. We should not have, in a federal country, it cannot be the case that the Constitution can be amended unilaterally by one order of government. So, as derived from the fundamental character of the Canadian polity, right, that we can see in the written constitutional text. Yeah? So here we have a moment in Canadian constitutional history, an exercise of the constituent power, which is in theory unconstrained, which is constrained, but it's constrained through the ancient constitution, through the constitutional conventions, enunciated by a court in the kind of role that a court takes under a modern constitution, through principles derived from the written constitution. So this is an illustration of the complexity of answering the question, what is the Canadian Constitution? The Canadian Constitution is a mixed constitution. And the fact that it is a mixed constitution has consequences on how we understand the Constitution, even under the conditions of the exercise of constituent power. Okay, so I'll conclude, as I see I'm running up against the 15-minute limit. of the 15 to 18 minute limit. I'll conclude by saying, look, I think that this has this understanding of the Canadian Constitution has implications for how we should interpret the Canadian Constitution. And this is in the form of, I think, what other panelists yesterday described as a promissory note, which I think means that I haven't written out the full argument, and I haven't really worked out the full argument. So I'm looking forward to a conversation about it. So in Quebec, there is recent, and in Ontario, there's discussion about this use of the Notwithstanding Clause. And so again, for those of you who do not do Canadian constitutional law, there are some provisions of the Entrenched Charter of Rights and Freedoms, entrenched constitutional rights, which can be, and well, the verb is important, but not so important for present purposes. Essentially, the legislature can suspend those protections for a 5-year period. Yeah, provincial legislatures, and in theory, the federal parliament, well, parliament has never done so. Now, what is this? What is this power? Yeah. So one version of understanding this power is to think of it as an act of the constituent power. Yeah? That is, it is unconstrained by any constitutional norms. It is not limited by anything other than the sovereign will of political actors. And I want to say that the mixed character of the Canadian Constitution should lead us to question that understanding of the exercises of the Notwithstanding Clause. We should understand that clause within the broad range of the character of the Canadian Constitution and the commitments that underlie it. And so, as I say, this is a promissory note. This is not an argument. But I want to say that it is at least plausible to say that simply because a provincial legislature is able to enact the Constitution, able to enact the legislation using the Notwithstanding Clause to insulate it from constitutional review, does not mean that it is immune from constitutional evaluation and constitutional assessments, and that in some sense, an invocation of the Notwithstanding Clause can be unconstitutional, violating the mixed character of the Canadian Constitution. So I'll leave it there, and I look forward to the conversation.
Well, Hoi, talking about the Notwithstanding Clause made it impossible for me to cut you off, even if you just kept talking there. So I'm glad you kept yourself within the limits. So now we have Professor Gargarella. Roberto, you're on the deck, and then we'll turn back to all these questions and open up the floor.
Thank you. Can you hear me? Yes. Okay, this is an exercise of more abstract constitutional theory, but hopefully will be more or less in dialogue with what was just said. I wanted to make a reflection on the place of judicial review in a deliberative democracy, in a dialogic democracy. And to start with, I have been for many years interested in constitutional dialogue, and also critically on the study of judicial review. And because of that, I mean, thinking about the place of judicial review in a democracy, I have been very much interested, for example, in the Canadian initiative for the Notwithstanding Clause. That was very attractive because it was a first attempt, and for me was a very modest but an interesting attempt to walk in the direction of putting together judicial review and more dialogic understanding of constitutionalism. But after so many years, or for decades, I feel so much discomfort with that that attempt, and I was wondering why. And so, in part, it's a reflection out of that. No, first, I would say that my discomfort with the solution offered by the Notwithstanding Clause was that it was based, I would say, on a problematic understanding of democracy, or an incomplete understanding of dialogue and democracy. My own view of that has to do with what I call a conversational understanding of democracy, a dialogue among equals, a conversation among equals. So for me, the whole point of democracy in a constitutional order is to have a conversation among all those affected by the norms that are going to affect all of us. And that requires the possibility of exchanging arguments, of mutual correction, of in the search of impartiality. No? So it's an exercise which is mainly a collective exercise, which I would characterize at least by two features. One is inclusion, but inclusion in a sense that refers to the whole population, and the other is dialogue. And dialogue in the sense of exchanging arguments and mutual correction. And I think that in many of the most contemporary attempts to rethink judicial review, we don't see that notion of democracy realized. And a good example of that missing the point is the Notwithstanding Clause, where I think, well, first, I would say that in terms of inclusion, well, I mean, it's basically refer to a dialogue, if it's a dialogue, between the political branches and the judicial branch, but where the people at large are basically absent. And that, I think, is a unjustified absence. So the people at large are totally outside of the picture. That's a problem. And the second, I would say that I don't think we can call dialogue any communication between the branches. So I mean, the possibility for the parliament to insist during 5 years with its own policy or its own decision, well, that's a new version of the old system of checks and balances, which is basically, I mean, the checks and balances mechanism is a mechanism basically to channel the civil war, but it's not an instrument for dialogue. So it has very little to do with dialogue. So I would say, in what sense this attempt, so the Notwithstanding Clause, has something to do with a broad understanding of democracy, so an inclusive understanding of democracy, and in what sense we can call that a dialogue? So in what sense we have an exchange of arguments? In what sense we have a mutual correction? So I would say that for the Notwithstanding Clause, but to other attempts. So what could be, if any, the place of judicial review in a dialogic democracy? Well, this is very briefly my approach is, well, what judges could do in a deliberative democracy, in a dialogic democracy, would be to protect, to safeguard the procedural rules of a conversation. So in that sense, I think that a procedural understanding of judicial review could work. And in that sense, I have been very much tempted to work with the John Ely's approach to the role of judicial review in democracy. But again, if we think about John Ely's view of the procedure, well, again, here we have a very restrictive understanding of democracy, actually a pluralist understanding of democracy. So I would say, in a deliberative democracy, judges should protect the procedures of the conversation, and that doesn't mean what Ely understood for that, because again, he had as a starting point a very restrictive understanding of democracy. And second, I mean, even though I approach to Ely's view with a lot of agreement, but I would share what, for example, I would go in the line of Stephen Gardner in a recent article in Icon, trying to rethink Ely's view of judicial review in a contemporary context. So I would say we need to, we who defend a procedural approach to judicial review and recognize that it would be justifiable for a judge to contribute to the safeguard of the procedures of a deliberative democracy, but the procedural understanding should be different from the one that Ely defends. First, because we cannot assume the view of democracy that he was assuming, I would say we need to change that. And I want to explore what would be the implication of that. And second, we need to rethink the contextual conditions of this procedural approach. I think that Ely had very much in mind the Warren period, the Afro-American problems with discrimination, and that's totally fine for that time. But again, we should make a different question. So just, beginning to conclude. So what could be the procedural role of judges, played by judges in a deliberative democracy? And what would be different from the Ilian approach? So first, I think that instead of subscribing Ely's view about representation reinforcing, we should think about what are the conditions, the institutional conditions, the institutional elements, the institutional factors that are impairing the conversation today. So I would say, I don't know, interest groups. I would say an executive power that became self-enlarged itself. So we have all these discussions during this decade about democratic backsliding, about democratic erosion. So I would say that a renewed exercise of judicial review in these conditions, if you want to favor democratic dialogue, you should particularly take into account the reality of an executive that expanded its powers so much. This in Latin America is so clear that should be obvious, but it's now obvious after Trump in many other countries. So we should think about the way in which the executive power is impairing the possibilities of having a large conversation. Second, we should be, we judges should be particularly attentive of what Kasanstein called these laws that are just the product of naked interest. So again, we want legal decisions to be based on public discussion and not in naked interest, and not just be the product of interest groups. So again, in a dialogic democracy, judges could have a particular role preventing the enactment of laws that are just the product of naked interest. Third, Ely was mainly thinking about discrete and insular minorities. Well, I think in contemporary societies, clearly this is the case in Latin America, where you have a vast majority of the population living in poverty. Well, we have to see, and again, I think judges could have a role here in the sense of how to include the voices of these impoverished minorities or impoverished majorities that do not participate in any meaningful way in the collective conversation. Again, and similarly, so for example, in terms of social protest, judges should be particularly attentive to protect the voices of those who protest because they feel they have been mistreated in constitutional terms. So there are many things that could allow us to rethink the role of judges in a deliberative democracy today. Now, is it that I am basing my approach on a too naive or a too idealistic understanding? Because I defend a collective conversation for dealing with all of our public problems. Well, the truth is, when we look around, even in Latin America, but clearly in other parts of the world, we have constitutional discussions that were surprisingly, wonderfully inclusive. In Iceland, in Ireland, now in Chile, we have just a panel on that. So, in the very first moment where the government opened the door for a public conversation on the Constitution, as Claudia Hayes was saying in the previous panel, 200,000 people jumped into these opportunities to discuss about the constitutional reform, or even in my country, which I'm from Argentina, and Argentina is not an example of anything. Institutionally, this is a catastrophe. But even here, We have 2 years ago a discussion on abortion, which was exemplar, and it was a discussion on such a difficult issue, such a divisive issue, that we have in the streets, in the schools, in the cafeterias, everywhere. All the people discussing about, so it's possible, it's necessary, and is, required in a deliberative democracy to promote that. So the idea that we shouldn't just encapsulate the decision-making process in the old mechanisms that are not inclusive at all, that leave us, all of us, outside. So it's possible to think about a process of a decision-making process which is more inclusive and which is more deliberative. So it's not that I'm thinking about an utopia. All the experiences we have all around, I would say, not only, in Canada, provided wonderful examples in Ontario and British Columbia about citizen assemblies. Well, that's possible, and that's interesting, and that is, I would say, democratically required. So to conclude, I think that those of us who are interested in rethinking judicial review for a deliberative democracy, well, we have a long way to go in order to start examining, understanding the practice that is outside and seeing what is interesting about that and learning from it. There is a lot to learn from what the practice has been shown to us. So today is not anymore the place of the utopia. It's a place of a possibility that is out there, whether we want to transform our restricted democracies into something different, more inclusive, more dialogic, etc. And judges could have a role in that. Just to final note, I have been, all my life very critical. I'm very critical of the judicial organization and judicial review. So it's not that I'm confident about what role judges will play tomorrow or the next week. I think that all the incentives are in the wrong direction. And so I think that under these conditions, judges are able to do very interesting things in the name of a dialogic democracy, but under these conditions and these institutional incentives, I think that the chances that they will do that are very low. So I think that in order to favor this, we need also institutional reforms. So in that sense, and with this I conclude, that's why the Notwithstanding Clause was interested in the very first minute, because it showed that you could do some institutional change that improve the institutional conditions of dialogue. So there are things that could be done and should be done. The step was too modest, and in a way I think would say it was wrong, but it showed that it was possible to do something institutionally in order to go in the direction of more dialogue. So I conclude with that.
Well, that was fascinating. All of the speakers have done great, and I've been glad I haven't had to cut any of them off because it's been fascinating. I'm happy to open the floor to all of our panelists to ask each other questions. First, I have a couple of questions for you myself, and I'm happy to pose those. But first, maybe do you have anything you want to ask each other, or anything that really struck you about overlaps or questions about your other talks, or your own things you want to clarify from your own talk?
My part, I would say that there is a connection. I was not talking directly about Canadian constitutional law, but I was saying something that are relevant for the other presentation. So in particular to Professor Hoi, I would say that I don't find so promising the idea of the sovereign and the constituent power. I would say I would be much more, in a way, modest and go to the common sense of the way we understand, and we need to understand democracy today in an inclusive way. This is possible, this is there, this is important. All those things that affect all of us I mean, we should all play a role in that. So I would go in that direction, rethinking about democracy instead of going to this mysterious notion of the constituent power. No. So one thing that would be one thing.
No, that's great. Thank you so much. And I happen to agree with you. And so actually, I work. Ron Levy, Flynn, and I have just published a book, Deliberative Peace Referendums, and a little bit about how to, even under conditions of like deep conflict, how you can do constitutional reform in a way that is precisely in accordance with what you are suggesting, Roberto, the norms of deliberative democracy. I think what's interesting is how we understand those norms in an act of constitution making. Right? Are those norms in some sense constitutional, or are they purely prudential, purely in in Erin's terms, purely political? Yeah, and I think that there's at least a possible argument to say that if you don't abide by at least some of the basic elements of deliberative democratic requirements, it's hard to call any constitutional process that you're engaging in a constitution-making process, as opposed to just a sheer act of pure political will.
No, I think that we are all day, in one way or another, engaged in the process of interpreting the Constitution or basic constitutional values, how we understand important. So of course we need to support that with rules and procedures, but of course we are discussing about the Constitution, and that's fine, and that's a totally legitimate exercise. Sorry.
Hoi, can I just push you on that point, Hoi? I think that one of my questions for you was whether or not it made sense he's drawing on Peter Russell's old thesis that Canada in terms of your paper, because it involves peoples rather than just one united people. And what I thought was, well, I've read your stuff on republicanism and federalism, and isn't there a story here where, isn't there a sense in which the Canadian people, act as a people as they're incorporated through the negotiations between the First Ministers and their respective legislatures that they're responsible to? I sort of thought that's where you were going to go right away, and I just wondered if that connected back to your own Republican work. And it sort of sounds like that does sound, if that is a story, it does stand somewhat in contrast with Roberto's call for something more participatory and less representative, and less of a kind of having less of a representative agency story or collective agency story, and more of a direct participation. Roberto, it sounds really like you want there to be more things like the Citizens Assembly, and maybe Hoi, you don't think that's exclusive with your view, but it sort of sounds like there's some tension there at least.
Great, thanks so much. So I would say that's not exclusive of my views. I think that I inform, the more deliberation, the better. And I think the challenge is how you structure, as Roberto said, like how do you structure this stuff institutionally in a way that it position. On the question of what counts as popular sovereignty within the Canadian constitutional order, I think my basic point is that it's contested, right? So what counts as the people is a perpetually contested question in Canada, yeah, and probably in many others, but I think like for a whole bunch of historical reasons, truly contested in Canada, and it sort of forms a kind of a core feature. This contestation forms a core feature of the people, as you might, the sovereign, whoever the sovereign is in Canadian constitutional law. If there is a sovereign people, that is, the identity is is always contested, and that's an essential feature of the Canadian polity. Now, that doesn't mean that in certain circumstances we can't try to ensure that interests that have representation within the existing system as part of that contestation, right, are protected. And so the piece that you're referring to on federalism and republicanism, the idea is that, yes, we have features in which we safeguard against non-domination within the Canadian Federation along certain axes of identity, which are important to the understanding of national identity. Yeah? And so one of those is the division of powers, and one of those axes, one of the mechanisms is the protection of the provincial jurisdiction, and in particular Quebec. So I don't think that there's inconsistencies. I think that part of the story is that it's really complex, and the challenge, I think, in both, as we see both in Roberto's interventions and in Erin's interventions, is how to make these things live through institutions rather than just in theory.
Erin, my question to you was, I was reading Ted Morton's article reflecting on, I think earlier in his career, he was one of these Calgary school guys that we talked about yesterday, cowboy from Alberta who wants to, I think he's actually originally from Wyoming, who wanted to the provincial government. And I was reading something where he was, I think this was a year ago and lots happened in between, but he was reflecting, saying that he really abandoned his ideas about that, thinking that, we could tie our hands, but that would actually make it easier for the federal government to dominate us. Did in the trade war this year, right? Is there a sense in which there's some potential tension between entrenching cities and provinces actually resisting domination, being pushed around by other provinces or by the federal government?
Yeah. So I think that it's helpful to think about how constitutions can be both enabling and limiting. And I think what we have in the case of the provinces is a constitutional framework that is enabling, right? When we're talking about a political constitution, because we're really talking about parliamentary sovereignty. And it's made more complicated because parts of the provincial constitutions are also part of the Constitution Act, the Canadian Constitution. So it's definitely not a free-for-all, but I think when you're looking at entrenching a provincial constitution, one of the trade-offs is it's going to be limiting in terms of the powers that the province then exercises, and it's limiting itself. And there can be reasons why you might want to do that, but I think
you have to follow this procedure to special supermajority voting procedure to, let's say, to vote about changing city size and all these different dimensions of cities. And then they'd have to have a manner and form, a law about the manner and form law in order for there to be some kind of real functional entrenchment as a result of whatever was constitutionalized. Is that sort of the idea? But I was wondering, is that potentially challengeable on division of powers grounds? Because the province might be tying its hands in a way that prohibits it from exercising its jurisdiction along other allocated powers under other heads of power under the Constitution Act 1967, right?
Yeah, so when I originally presented this paper, I was on a panel with Hoi, and his paper, so I might put it to Hoi because his paper addressed the question of whether or not manner and form requirements are constitutional, if you could do this kind of double manner and form. And I think, Hoi, I think your position is no, yeah, in part. And so even the use, so there is some question about if we were to go about giving cities greater powers, could you actually go about it using Section 45, or does it have to be Section 43, which is using the amendment procedure that requires both the approval of the province and the House of Commons and the Senate? And I don't know if, Hoi, you want to build on that, because you talked in more detail about that in that earlier paper.
Yeah, so sure. I mean, I think, look, the challenge of entrenching under a provincial constitution is that it constrains legislative supremacy, legislative sovereignty of the provinces, which is clearly a core principle of Canadian federalism. And we have the sort of sole source of the supremacy clause, the ability to constrain legislative supremacy, is really in Section 52. In the supremacy clause. So it gives rise to all kinds of interesting puzzles of Canadian constitutional law, which may not be of that much interest to other people. But I think it's at least inadvisable, and in my view, probably unconstitutional. But I think to sort of attach our conversation to Roberto's point, Roberto's paper, I mean, I think that what's really sort of super important in these questions is why do we think that it's important to give cities power? And I think one of the reasons why we think it's important to give cities power is because cities are subject to regulation without any of the sort of requirements of justification that we would normally require under a deliberative democracy. Yeah, so that is basically under the sort of complete whims of higher orders of governments. You can undermine the capacity of city governments, which are democratically elected entities, which reflect the considered views of their populations. And so that's a problem, I think, for deliberative Democrats, as well as for people who are interested in Canadian constitutional law.
No, I would say, I mean, it's important to distribute power and give power to cities and to other entities, just in order to follow, the direction of decentralization, and also, taking notes of the way in which power has been concentrated and how that, endangers the conversation. But again, I would say it's super important to decentralize authority, but at the same time, we have the risk of fetishizing a new entity. So the cities are not the people, and so we want to know, what different individuals think about a different situation, and so I would be careful in this. Refine again that what is important is, the individuals that compose that entity. So of course, I know, we cannot get together in the main square and discuss all together, but we know that there are alternatives to exchange and to think collectively about our common problems, so that we could go for. So in that sense, yes, to decentralization, but also, without forgetting that we care about the individuals that compose all those collective entities, no? So, and I don't think it's just a matter of methodological individualism. It's a matter of knowing about politics and how politics has been transformed into bureaucracies and interest groups, and so this is something we need to think about today, because we all recognize, all those of us who think about democratic erosion, we know what this has been implying. So, well, that's I thought.
Roberto, would you see like examples of provinces beating up on cities?
No, of
as
course,
an example of the erosion you're talking about is what I'm meant to say.
I don't want to give many examples from my region because I don't know the distances with, for example, with Canada could be so large, but in my country, for example, when you decentralize, you are basically giving power to, I mean, restoring feudalism in a way. So in many of the provinces, in many of the cities, I mean, away from the center, well, power is still organized in a very vertical and non-democratic way. So in that sense, one needs to be aware of the importance and the risk of decentralization. No? So it's both super important, but for democratic reasons, not for itself. No? So in many occasions here in Latin America, I would say decentralized is to give power to very old hierarchical structures. No? So in that sense, maybe I'm too biased because of this Latin American approach.
So you're saying decentralization could actually increase some of the problems you're talking about,
yes,
but
absolutely.
It may be not if it took a special kind of form involving more popular extra institutional participation. Is that what you're getting at?
Yes, but the thing that decentralization is more and more important. Provinces are organized in a inclusive, conversational, dialogic way, democratic way. If not, as it happens in so many different parts of my country and other countries, well, there is a risk of decentralizing, no? But that, I mean, in a way, is the same debate that federalists and anti-federalists were having in the United States in the end of the 18th century. And so many of the anti-federalists, which I read and I enjoy so much, but they were not defending decentralization, but many of them were, I mean, just the feudals, the owners of the city. So in Pennsylvania, and many other places. So is the older problem, no? That we need decentralization, but we need to care about the way we decentralize. But that's
right. I do think that the anti-federalists are many of them are very interested in specific interest groups getting their way.
No, I had a question to Hoi about what you say about the contested concept of the people. That's true and that's very important. But at the same time, I mean, we shouldn't take that as an excuse because we know at least what is not the people. So we know that lots of, I mean, individuals and institutions speak in the name of the people, but without really having the authority to do so. So I mean, it's polemic, it's contested, but well, I mean, there are things that approach very much to the people in the sense that has to have something to do with public debate, with an inclusive public debate. And if we don't have that, well, then it's a problem. So it's contested, but not impossible, no? So to distinguish, but
I absolutely agree. I think it's contested. And so what counts, to go back to sort of Geoffrey's question, what counts has to satisfy some requirements of deliberation. Yeah. So it cannot just be a pure assertion, and it cannot just be an assertion based on exclusion, which is, I think, sort of the examples that you've given. Yeah. I think the question of what role the judiciary plays in all of this is really, really important. And so, Roberto, when you talk about the inequalities in socioeconomic inequalities. Yeah. So one way of reading this is to say, look, we give more deliberative power to underrepresented groups and give them influence and provide them with influence, avenues of influence into government. Yeah. So that's one way of handling the problem. Another way of handling the problem is to say, look, we need massive redistribution because there's no possibility of meaningful deliberation under conditions of extreme poverty. Yeah. But the challenge, I think, is if we go with the latter, there are standard issue objections to whether or not this falls within the institutional capacities of the judiciary, right? And please.
No, but it's not that because judges may have a role in protecting democracy. I mean, they have to do the social reform. So it's not that okay, now we recognize this is the solution, let's go with judges. No, not at all. They have not the capacity and not the legitimacy. But I was thinking, about other things. So, for example, in terms of social protest, which has been so prominent here in the region, but I think also in other places. So usually the main reaction by judges in the face of social protest was saying, oh, no, I don't know, you are, say, blocking the transit, or you're, so that's a problem to our constitutional democracy. And I would say, well, no, in conditions where it's so difficult to have access to proper institutional means to transmit our concerns, our complaint to our representatives, well, the first thing you have to do is to protect those voices and try to pay attention what they are saying, why they are protesting, so they could have a very different approach to these things if they start from a deliberative understanding of democracy. So we need to pay particular attention of the voices of the marginalized, not because they are right, but because for reasons that they are not their own responsibility, they have problems to have access to the public forum. So in that sense, they should give a special protection to those voices, no? The voices of the marginalized, in that sense, for example.
All right, maybe we'll open it up, the floor up to, let's open the floor up to any questions from the audience. If you could just, if you have your hands raised, I will call on you. So I think I see, yeah, Professor Dawood, would you like to go?
Hello, everyone. Can you hear me?
Yeah.
Okay, terrific. That was a fantastic panel. I so enjoyed all the presentations. I have a question for Erin and a question for Hoi. My question for Erin is the following. Do you think that there is any kind of interaction between those two kinds of constitutionalism? So, for example, political constitutionalism on the one hand and legal constitutionalism on the other. And if so, how might that cash out when we think about the constitutional status of cities? So that was one question, because I really liked in your paper your push towards political constitutionalism, but I wasn't sure how those two things interact together. I don't know, Geoffrey, do you want me to give both questions or one at a time? What would you prefer?
Well, let's do that first one. Let's just do it one at a time then, if you'd like that.
Okay. Thank you. So that is a really excellent question, and I don't think I've thought about it in those terms before. And of course, you know, no constitution, at least when we're talking about Canada and probably not anywhere in the world, is one pure form of a political constitution or a legal constitution. And certainly in Canada, that is the case. But it's helpful to distinguish between the Constitution of Canada that seems to be moving towards a more legal constitutional framework versus the provinces that can still, at least within the jurisdiction that they exercise, still operate under a political constitutional framework. And so I think in drawing out those comparisons, the helpful part is to think about what some of the proposed reforms would do, which when we're talking about a city charter that is brought in through a Section 43 amendment that would require both the House of Commons, Senate in the province, that we really are moving that totally to a legal constitutional framework, that any kind of dispute between a province and a city would then be resolved through the courts. Whereas if you kept it within the provincial constitution, it is ultimately a political dispute that gets resolved. And I think when we're talking about likelihood of reform, that provinces are going to be really reluctant to move towards that legal constitutional framework because it does take that power and jurisdiction away. And that's always obvious, right? If you're giving more cities or more power to cities, it's going to be less power for the provinces. But thinking about it in these terms lets us, I think, theorize it, perhaps in a way that is helpful.
Yeah, that is very helpful. I gather from what you're saying that the political constitutionalism, in some sense, takes place in the shadow of the legal constitutionalism or something like that. Like there's some, it's sort of there, even if you're in the political realm. The legal constitutionalism is hovering or is somehow influencing the kinds of choices that people make, and also crucially, the kinds of choices that people avoid.
Yeah, and this is my second paper on provincial constitutions that I wrote this year, and I never thought I would write on provincial constitutions, but the first one was on provincial constitutional amendments, and I was just fascinated by this fact that every year there are obviously amendments, amendments to the provincial constitutions that are happening, but I don't even know if the legislatures are aware that they're making amendments to the provincial constitutions, because it's a regular what is in a provincial constitution. It might not even occur to you that you're amending your provincial constitution. And so it is, so I called it amendment by stealth, but it really is operating in the shadows. And I think in some instances, people are not aware that they might be, elected officials would be aware that they're amending their constitution. So it's not even quite it about why you wouldn't want to make this change, because for lots of provincial legislatures, they're probably not thinking about what is in their provincial constitution in the first instance.
Well, I look forward to reading more about your work. It's fascinating. So I have one question for Hoi. I think it's such an interesting paper book that you're writing, like what is the Canadian Constitution? And I guess one question I had while listening to your presentation is, where does meaning fit in? How do you deal with the meaning of it? And so then I started thinking, and I think you might have already talked about this a little bit in the intra-panel discussion, but how does judicial interpretation of the different provisions, where does that come in? So for example, what's included if we think about any of the, let's say, charter provisions? Some of them have, sort of been ignored. Others have had, thousands of cases, not thousands, but many, many cases telling us what they mean, what the Constitution is? Or are you drawing a line somewhere which says, we're going to really just think about all the statutes and all the conventions and all the various documents that add up to the Constitution, but we're not really going to think about the meaning as courts have told us what it means, or something like that?
No, that's a great question. Thank you. So I think that, interpretation. So for the book, I think interpretations of the Constitution will be included because effectively the interpretations are entrenched once the provisions have been interpreted. So I think I will include that as part of the definition of the Constitution. But yes, it's a very helpful clarification. And so the answer is yes. That it's I guess they would fall in even within a sort of broad understanding of what the criteria of inclusion are. So it's not just the artifacts themselves, but how those artifacts have been given effect.
Great, thanks.
Great, well, thank you for that exchange. I think our next on our queue is Professor Levy.
No, Victor was first, and I'm happy to wait behind Dwight as well.
Oh, okay, Victor.
Oh, all right. Well, thank you. So I have a question for Erin. I don't know if it has an answer. It's just thinking in terms of the kind of autonomy that cities have. I mean, my mind immediately goes, just like it always goes, to something like the Holy Roman Empire's free cities, because the threat to a city's autonomy it really comes from the province much more than from the federal government. I mean, it's the most proximate power that tends to threaten you, which of course would seem to point to the federal level as the safest place for a city to seek some kind of autonomy. But the problem there, and I think that there's kind of a Machiavellian gloss to this, that when Machiavelli says always side with the people against the nobles, because the nobles are the ones who are going to betray you, and they're a little bit too powerful. There's a sense in which if the federal government sides with the cities, that the provinces get crushed in the middle, right? That is, if the federal government is the one directly protecting the cities. So then we end up in the position that I think you correctly identify as provincial protection. Now, the problem there is that when I compare it with the most immediate example where you could have some, and occasionally you do have some provincial protection of urban autonomy, which is in the US, I think that the way in which the Americans can get away with it and the Canadians might not be able to get away with it, away from this problem of crushing the province in the middle, is that they have two levels of judicial interpretation, where in the Canadian case, a provision, even a provincial provision protecting cities, will be interpreted by the same court that is a unified court system all the way up to the Supreme Court, which would not really solve the problem of having the provinces to some degree internalize the costs of giving cities a certain amount of autonomy. So I wonder if the structure of judicial interpretation is something that ought to be factored into the analysis. The fact that, especially because the Supreme Court has said, for instance, that if it has to interpret a provincial statute or a provincial charter of rights or provincial constitutional provision that has very similar language to the federal provisions, it's just going to interpret it the same way. Where in the US, you don't have that kind of pressure. You have the ability of interpreting the exact same text differently. I think that judicial structure has some part to play in this. I don't know exactly what.
Yeah. So, I think advocates for this change probably haven't thought quite as far as you have in terms of what it means for the courts. Because right now I think it's very much kind of these local groups thinking about their particular city and the needs of that particular city, and not potentially the consequences of us having a court system that could impact others. So that could be another potential barrier to this. And of course, comparing to the US, that Canadian provinces are much stronger political entities than the states, and so are likely to be more reluctant to give up that power. And I'm just thinking about, under what conditions would this likely to happen, that we would have kind of meaningful recognition of a city in terms of constitutional status, rather than just kind of a throwaway, a guarantee of consultation, or if we get to a point of a mega city where there are enough provincial elected representatives coming from that city that they could act in the interest of that city, that could push some sort of reform within the provincial legislature. But of course, even within a city, there's going to be different political views. But I think I wonder if that's the most likely scenario. But that doesn't answer your question, which I think is a really good question to ask. But I don't know if it has an easy answer.
All right, great. Well, next we have Dwight Newman on the queue.
Hi. So it's a question to Hoi concerning the shift, your discussion around the implications of the Notwithstanding Clause for the meaning of the Canadian Constitution. I think that's really interesting. But I'm curious around the shift in the use of the Notwithstanding Clause in recent years and how that connects into this, because you had a lot of politicians of certain parties and a lot of academics who were trying to put forward a taboo around the use of the Notwithstanding Clause for a long time. And then you relatively suddenly had 3 provinces at around the same time make use of the Notwithstanding Clause in Saskatchewan, Ontario, and Quebec. And I'm just wondering what your thoughts would be on that sudden shift towards a use of the notwithstanding clause. Is that a chance thing? But insofar as it relates to the supposed taboo that existed, were a lot of people just confused about that? Or has there been some kind of shift in the meaning of the Canadian Constitution insofar as the notwithstanding clause bears on that? Or just how do you grapple with that apparently sudden shift?
Really great questions. Understanding this, sort of, let's say, the jurisprudence around the notwithstanding clause, it's relatively unconstrained as restraints of justification. And so as long as there's a taboo around the notwithstanding clause, that kind of lack of constraint isn't important in sort of Erin's terms, because the kind of political practices are constraining its use. Yeah. But once it's being used more, I think it opens the door to reflection on what are the criteria for justification for the use of the notwithstanding clause, and should they be higher once that political practice has changed. Yeah. And that's, I think, a kind of both a political constitution question and potentially a because I think it sits at the borders between, in my terms, the borders between the ancient and the modern constitution.
Great. Jacob.
Frame one that's both for Erin and Hoi, but the question for Erin is specific enough that I'll just ask it separately. Toward the end of the paper, you shift from the question, are cities already constitutionalized, to the question, are cities already entrenched? And I didn't know what that change meant, because as far as I'd understood the paper up until that point, to be constitutionalized in a provincial constitution is not to be entrenched. That
kind of put together a little bit more into the paper since I submitted. Has it evolved into a constitutionally essential institution is, I think, one way of asking that question, because it's the question that the Supreme Court asked itself about itself in the reference institution to have evolved to become something constitutionally essential, that it can then be part of a constitution without the So I added that into the paper in part because Hoi is really good at leading me in new direction now.
Okay, I had also had some interest in trying to stir up a fight between Erin and Hoi on the relationship between the political legal distinction and the ancient modern distinction, but we're at time, and that's a big sprawling question, and I think that I'll try to take an opportunity for that then.
Great. Well, we're at time, so I believe that will break now, but people can still chat in the leftover session. So they'll